Here to discuss the case of a 7-year-old boy in New York State charged with rape and other issues related to the arrest and prosecution of children is Marty Feinman. Marty is the director of Juvenile Delinquency Training at the Legal Aid Society's Juvenile Defense Practice in New York City. Thank you so much for coming back on, Marty.
Thank you. It's nice to be here again.
All right, so let's begin with the case out of upstate New York that I mentioned, of a 7-year-old child charged with rape. Now, I can't even imagine how a child that age is physically capable of rape, let alone has the mental capacity to commit the crime. So please explain the legal basis for charging a child that age with such a serious crime.
Well, I wish I could explain to you the legal basis, at least with any degree of certainty or clarity. Obviously, for very good reasons, there's very little that the public knows about the case because of the 7-year-old, because it's family court, because of the need for confidentiality. There's very little information that is shared with the public. But it's hard to imagine how a 7-year-old engages in conduct that could legally qualify as rape. We don't know whether the charge is rape in the first, second, or third degree. But regardless of the nature of the charges, all of those rape charges involve elements that presume a certain level of awareness and a certain thought process on the part of the perpetrator to justify charging somebody with such a heinous crime. And all of those presumptions have little support in reality or in science when you apply them to the conduct and the thinking of a 7-year-old.
Now, I understand that New York has the second lowest age of criminal responsibility in the nation, with only North Carolina having an even lower age at 6. Some states have no minimum age at all. In Florida, for instance, children as young as 4 have been arrested. Now, I know in New York, legislation has been introduced to raise the age of criminal responsibility to 12. Will that bill pass? And is there similar legislation being proposed anywhere else across the U.S.?
Well, will that bill pass? I sure hope so. And it's actually the New York State legislative session is coming to an end in the next couple of days. That bill has passed through, at least in the New York State Assembly, a number of the committees that it had to make its way through in order to get to a floor vote. And we're hoping within the next day or two, we'll find out about that. The majority of states do not have the kind of limitation that we're seeking to establish in New York State, but there are many that do. Most notably, California has that kind of a law in place. Utah, I believe, has that kind of a law in place. And Massachusetts also has a very similar law in place that would do away with the arrest and prosecution of children under 12 charged with any kind of an offense. And what we know about how that's played out in Massachusetts and the other jurisdictions that have that kind of law in place is that there has been no downside to it. The critics would argue that this is going to create more danger in the community, that this is going to result in these children not getting the level of intervention and assistance that they need. And there is nothing in what we know about the experience in these states that have this kind of legislation that would suggest that that's been true, that these children have not been able to get the kind of services and the kind of treatment that they need through other mechanisms in the community other than the juvenile justice system.
Now, separate from the age when a child can be criminally charged, can you explain how kids can be charged as adults? I know the law on that has recently changed there in New York, but it seems we frequently see media reports of teenagers facing life in prison, and we'll continue to see that now that the Supreme Court says it's okay.
You know, I mean, it's complicated. It obviously varies from jurisdiction to jurisdiction. The question that you're asking speaks to the science that's out there, and speaks to the expanding body of science that is teaching us more and more and more about adolescent development and about what we can and can't reasonably hold children and adolescents responsible for, what they are capable of appreciating, what they aren't capable of appreciating, what they recognize, and that they are not adults. They're not miniature adults. They are adolescents and they're children, and they need to be treated very, very differently. And there is a tremendous movement around the country. New York State was one of the last states in the country actually to raise the age of jurisdiction. New York State, it used to be that once you hit 16, you could be prosecuted as an adult, and I won't bore you with the details of all of the aspects of the legislation in New York State right now, but for the most part, 16 and 17-year-olds charged with felonies, while their cases begin in the adult system, they can be removed to the family court system, which is an acknowledgement of what we know, what social science has taught us about adolescent development. Same thing is happening, as we discussed last week, with regards to juvenile interrogations. And that same science applies to raising the lower age of jurisdiction. That science has told us that these children lack the understanding and the culpability to appreciate the consequences of their behavior. They don't understand the nature of court appearances. They're not in a position to be able to effectively assist their attorneys in their own defense. They lack impulse control. And the notion of charging them with criminal offenses in order to bring them into the juvenile justice system is ludicrous. The same services that the juvenile justice system seeks to provide these kids can be provided without bringing them into the juvenile justice system. And I have to emphasize that when I say these kids, we are talking, and I believe that you've put some statistics on the screen, we are talking in New York City, and I think it's true for most of the country, we're talking about kids who are disproportionately kids of color. We're talking about Black and Latino kids who make up 90% in New York City of the 7 to 11-year-olds who were arrested for these kinds of offenses, even though in the general population they comprise no more than about 57% of that population.
Now, we saw recently horrible video of police pepper spraying a 9-year-old girl in Rochester, New York. And we've seen police using excessive force against children and certainly restraining them by using handcuffs. Are the laws that govern police use of force different when dealing with minors?
They are. Again, it varies from jurisdiction to jurisdiction. And to be perfectly honest with you, I can't tell you with much specificity, but generally speaking, the use of force that can be allowed, generally speaking, the kind of force that can be used to restrain youth, a variety of jurisdictions have regulations in place to limit what law enforcement can do when they are engaging youth. Sadly, we see those kinds of abuses all too often. I recall seeing video a couple of years ago of a youth, I believe, in a facility in Arizona, or school in Arizona, and if I'm not mistaken, this youth was a disabled youth with no limbs, and the police physically subdued this youth who was misbehaving. I may have some of the details wrong, but it's an example of the kind of force that is often used against children, where that force is excessive and unnecessary, and it either reflects bad judgment on the part of the police involved, or a lack of proper training to enable those police to appreciate a more effective and appropriate way of interacting with those youth.
Marty Feinman, Director of Juvenile Delinquency Training at the Legal Aid Society Juvenile Defense Practice there in New York. Thank you for your wealth of knowledge on this issue.
My pleasure.